What is the purpose of trademarks? The purpose of trademarks is to enable consumers to distinguish the source of products and services, as well as help businesses defend the quality and reputation of their goods. Trademarks protect consumers and businesses alike by preventing confusion in the marketplace. The most common way in which trademark infringement causes confusion is through similarity. In the words of the Lanham Act, no trademark may be registered which so resembles another name or mark that it will be likely to cause confusion or to cause mistake or to deceive. How do the courts determine similarity? To determine similarity, the mark must be evaluated as a whole rather than through its individual components. This is important because there are only a limited number of parts, words, names, shapes, symbols, or devices that can be used separately or together to create a unique and distinctive trademark. The courts generally look at 5 factors to determine if a defendant's use of an existing mark is likely to confuse consumers. The 2 most important are: 1. The similarity in the overall impression created by the 2 marks, including the mark's look, phonetic similarities, and underlying meanings. 2. The similarities of the goods and services involved. But courts also look at 3 other factors. 3. The strength of the existing mark. 4. Evidence of actual confusion by consumers. 5. The intent of the defendant in adopting its mark. The key test for similarity is resemblance, not sameness. So 2 marks do not necessarily have to be exact mirror images of each other to be legally similar. Similarity is not the only basis for assessing infringement. The question is also whether similarity between marks is likely to confuse consumers, taking into account factors like the similarity of the goods and services on which the 2 marks are being used. For example, if a company that made metal chains called itself LinkedIn, that would not likely cause consumers to believe that the chains came from the same source as the social networking site, because the businesses are highly dissimilar. What are types of trademark infringement? An entity can be guilty of contributory infringement if it intentionally encourages the infringement of a valid mark by a third party. One can also be liable for contributory infringement if one continues to produce or distribute a product with knowledge that the beneficiary is infringing a mark. Another type of infringement is vicarious infringement, as described by Cornell University's Legal Information Institute. A person may be held liable for the infringing acts committed by another if he or she had the right and ability to control the infringing activities and had a direct financial interest in such activities. The existence of direct infringement is required to establish a claim of vicarious infringement. However, it is not necessary for the alleged infringer to have intent or knowledge of the infringement. Vicarious infringement most often occurs on internet sites that allow outside parties to post or upload files. Finally, there is trademark dilution, which is described by the International Trademark Association as the weakening of a famous mark's ability to identify and distinguish goods or services, regardless of competition in the marketplace or the likelihood of confusion. The concept of dilution developed from the idea that because some marks are so well known and famous, they deserve an extra level of protection beyond the likelihood of confusion analysis. The Federal Trademark Dilution Act of 1995 created a federal cause of action for trademark dilution separate from infringement. Typically, an owner of a trademark eligible for dilution protection can prevent another company from using that mark no matter how dissimilar the goods and services of the 2 companies are. That makes dilution protection potentially broader in scope than infringement protection. When the act was revised in 2006, however, only marks that are widely recognized by the general consuming public of the United States are eligible for dilution protection. Google has protection against dilution. Your local dry cleaner does not. Possible remedies for trademark infringement include receiving monetary damages for lost profits and injunctive relief, but trademark owners almost invariably insist on injunctive relief to cure the infringement. That's because when a trademark is infringed, the biggest loss to the owner is not necessarily revenue, but the potential damage to the reputation of the brand. Imagine, for example, that a manufacturer in Bangladesh started shipping substandard athletic shoes with the Nike swoosh on them into the U.S. market. The loss of revenue resulting from U.S. customers mistakenly buying the Bangladesh manufacturer's counterfeit shoes might not amount to a rounding error on Nike's books. But if customers began to lose trust in the swoosh symbol as a reliable indicator of Nike's quality design and manufacturing, the damage to Nike's brand and future profits would be significant. The company would want to secure an immediate injunction against the importation of the offending shoes, and thereby stop the ongoing damage to its trademark and brand. Incidentally, in cases where the products being imported are not patented or copyrighted, the courts may only require the importer to stop use of the mark but allow for the continued importation of the product. In addition to injunctive relief, monetary damages may also be awarded in trademark infringement cases. Monetary damages are primarily aimed at compensating trademark owners for any lost profits and may be tripled if the infringement is deemed intentional.